I'm Drew Stevenson. This is for my administrative law class. And here I'm going to be talking about the case Nightingale versus United States Citizenship and Immigration Services, or USCIS. This is a case from the Northern District of California from 2020. And here we're talking about the Freedom of Information Act and what happens when the agency's resources are so limited that they really can't keep up with the FOIA requests or respond to them within the statutory deadlines that have been set. So let's dive in. The central issue in this case is the systemic failure of some subdivisions of Homeland Security, namely DHS, Department of Homeland Security, and ICE, to respond to requests under the Freedom of Information Act for what are called alien registration files, or an A file, within the deadlines that the FOIA statute sets. And here's a spoiler: the court is going to give summary judgment in favor of the plaintiffs, some non-citizens and their attorneys, against the government in this case because it finds an undeniable pattern and practice of FOIA violations in terms of the deadlines. Under the Freedom of Information Act, when an agency receives a request of what we call a FOIA request, they're supposed to at least make an initial determination about whether they're going to comply with the request within 20 days. There's a statutory exception that allows them to add another 10 business days with consent or with notice in unusual circumstances, but the default deadline is 20 days. This doesn't mean they have to produce all the information within 20 days. Sometimes it takes a long time to find and retrieve and redact the requested documents, especially if it's thousands and thousands of documents. But they have to let the requesting party know whether they intend to honor the request or if they're denying the request within 20 business days. Congress thought this was important, and they said that information is often useful only if it's timely, and long delays can mean no access at all in practice. So I want you to make clear in your mind what the issue in this case is. A lot of our FOIA cases are about an agency refusing upfront to produce the information that's been requested, and they invoke one of the FOIA exemptions as their basis for doing that. And maybe it's a bit of a stretch. And so sometimes we have a FOIA violation because the agency has said no. In this case, we're talking about a different kind of violation, which is the agency just never answers the request and never responds. And so they miss the statutory deadlines set forth in FOIA. What are A files? Let's talk about that for just a second. These are critical records of a person's past interactions with the Department of Homeland Security, or ICE. And so that's going to include times that they entered the country, removal orders, statements, and applications. And sometimes individuals don't have that type of documentation themselves, and or aren't able to give the information, come up with it in documentary form to give to their attorneys who are representing them. But the government has it all on file and it could turn it over. And in this case, they weren't refusing to, they were just refusing to respond because they didn't have time. These A files that are being requested here actually really matter in these cases. The files are an essential safeguard for non-citizens who are seeking various types of benefits that are promised under the statutes or defending against removal orders. It's often the only way for individuals, especially those who suffer from mental incapacity or trauma or have been the victims of scams, to show their immigration history both to the government and to their own attorneys. In this case, the government didn't deny widespread systemic failures to comply with the deadlines. They admitted that DHS, USCIS, and ICE that they haven't been complying with FOIA deadlines for at least 8 years. There were chronic backlogs. USCIS reported an A-file FOIA backlog every year since 2012 up to the date of this case. One of the problems with backlogs is that if you don't really focus on addressing them and getting caught up, the backlog just grows over time and gets bigger. And that's what happened here. The backlog FOIA requests and responding to them grew from 16,247 in 2015 to over 25,000 in by August of 2020. And 99% of the FOIA requests that were coming into USCIS were actually for A files, where people or their attorneys requesting basically a report or the file from the government about their immigration history. And so this was the largest portion of DHS's FOIA backlog. And so the processing times for responding because of the backlog meant they were exceeding their 20-day and the default deadlines and the extra 10 days, often by twice that amount or three times that amount. And there were a few horror stories where things had taken years. The court here notes that one unnamed DHS chief privacy officer had acknowledged that there are, quote, consistent and systematic delays with FOIA processing, which adversely impact non-citizens. There's delays in immigration proceedings, and it potentially extends their detention. Now, the agency here said that there was just this incredible volume of requests that they couldn't possibly keep up with, despite their what they called good faith efforts. And the court's response to that was that the statute actually had sort of a relief provision for what it calls exceptional circumstances. And it lists exceptional circumstances that might justify the agency having delays in response. And that does not include delays that are predictable. And after many years of this high volume, it's pretty predictable what the number of requests are going to be or what the volume of requests is, and that they're going to continue having this growing backlog. And so that doesn't count as one of the exceptional circumstances that the agency seemed to be implying they had here, unless the agency is showing that it's making reasonable progress. And in here, things were getting worse. They weren't coming in and saying, look, we've been working on this and we've actually made huge progress in addressing the backlog. And in a few more months, we'll be all caught up. Instead, things were snowballing out of control. The court thought that it was really predictable that there would be this huge volume of requests for information from non-citizens, given the aggressive immigration enforcement policies that had set in 2017 during Donald Trump's first term in office. So if they're detaining people more, deporting a lot more people, it's really foreseeable, predictable, and maybe inevitable that they're going to have a lot more people challenging their deportations and asking for hearings, and they are going to be asking for these A-file records so that the attorneys can prepare for those hearings. All of this should have been clear upfront and ahead of time. As I said already, the government here couldn't claim that they had been working on this and had already dealt with a lot of the backlog and they would be caught up soon. Instead, the backlog was getting worse. And in terms of their good faith effort, the court felt that they were relying on a patchwork of sort of short-term imperfect solutions, like hiring temp workers or outside contractors and offering overtime to their staff and so forth, instead of just doing the hard job of going to Congress and saying, we need more funding. If you want to have this many more deportations, we're going to need more staff to process the information requests that we get from those individuals and their attorneys. And the agency had been unwilling to seek an increase in its funding to cope with this, and so that it would be able to have permanent staff that could keep up with the FOIA requests. So what was the holding? The court granted summary judgment for the plaintiffs in this case and concluded that the government had a clear pattern of unreasonable delays in responding, even acknowledging these FOIA requests for A files from non-citizens and their attorneys. And basically, they were ordered to adhere to the statutory guidelines for these types of cases and to eliminate the backlogs. So let's wrap this up. That concludes our quick overview of the case Nightingale versus USCIS, a 2020 case from the Northern District of California. Thanks for watching.